Good afternoon and welcome to the Environmental Law Institute. You have joined us for the basics of land use law. My name is Chandler Randall and I am the Manager of Educational Programs here at ELI. We are so delighted to welcome everyone to ELI's annual summer school series, and I encourage you to join us here at ELI every Tuesday for summer school. For more information, please see the events page of our website, eli.org. I will note that every summer school seminar will be taking place by webinar only this summer to ensure the safety of our panelists, participants, and staff. Thank you for your understanding and for joining us today. At the end of today's panel, we will have time for a Q&A session. Please submit your questions through GoTo's question box, and please do not wait until the end. Send us your questions as soon as you think of them. I would also like to thank our outstanding panelists for joining us today to lend their leadership to summer school. While I will introduce them briefly, their full speaker bios are posted on our website, eli.org, and I would encourage you to check out their expertise in more detail there. As we begin, I would like to briefly introduce our panelists. Sarah Everhart is the Senior Research Associate and Legal Specialist with the University of Maryland Francis King Carey School of Law. Sarah is a graduate of Washington College and a cum laude graduate of Pace University School of Law. She began practicing law in Maryland in 2005, and her areas of expertise include land use law, municipal law, and environmental policy. Sarah sits on the agricultural law section of the Maryland State Bar Association. Peter Goldsmith is Senior Counsel at the Maryland National Capital Park and Planning Commission. He is a graduate of the University of Maryland and the University of Maryland Francis King Carey School of Law. Peter has experience in land use law and property-related litigation and has served as law clerk for the Court of Special Appeals of Maryland, as well as an attorney for Linnos and Blocher LLP. And last but not least, Emily Parrish is Vice President of Conservation for the Land Trust for Tennessee. Emily is a veteran conservation leader both in Tennessee and at the national level. Emily earned her bachelor's from Sewanee, the University of the South, and a master's in environmental law and policy from Vermont Law School. As Vice President of Conservation, Emily oversees the Conservation and Stewardship Program, including the projects of 9 staff and 2 offices. Thank you all so much for joining us, and with that, I would like to warmly turn things over to Sarah to get us started. Thank you all so much.
Okay, thank you. Thanks for that introduction. So I am going to start out with some basics of land use law, just kind of set the stage for my co-presenters to go into a little bit more detail. But I like to start just sort of in the beginning where planning and land use really came from. And before we had what we traditionally think about now as land use law, made up of planning and zoning, disputes were handled through nuisance claims. So if you didn't like what was going on near your property, you had to prove that what your neighbor was doing satisfied what would need to be done for a nuisance claim. And so planning and zoning were really established to try to prevent those types of actions. We all know that courts are busy, and a lot of what the law is really structured to do is try to reduce some of that backlog that's going on. And so it's important to think about that these laws are based in trying to prevent a nuisance. And so it's all a balancing act. You're balancing a person's right to use their property versus the impact of that use on another's right to quiet enjoyment. So that's the balancing act that everything you're going to hear about today takes into consideration. So what came first, the zoning or the planning? There was some early examples of city planning and zoning in large cities like Los Angeles, and New York City often claims to be sort of the first example. However, there was this first Standard Zoning Enabling Act that came about in 1924, and that was really what sparked things nationwide in terms of zoning, because it gave everybody an example of how this could be set up in a community and what these types of laws were supposed to look like. And again, this came about really because of incongruent uses being near each other. There was industrialism going on, so we had housing, residential communities backing up into industrial type uses in cities, and nobody wants their house to be next to a factory that's emitting smoke and stinky things and all sorts of things. And so there really was a need to protect these residential areas. And that sort of was the foundation for all of that. And property values. People wanted to know that if they sunk a bunch of money into their home, that it was that property value was going to be preserved. A few years down the road, we had a standard planning enabling act. And so that was an example that let communities throughout the country know how planning was supposed to go, what that looked like, and it really promoted the use of a comprehensive plan, which I'll talk about a little bit more in a few slides. Interesting to think about the conforming zoning to planning. And so you'll hear from myself and my co-panelists that zoning is supposed to be in accordance and in conformance with your overall plan for your jurisdiction. That's something that we hear again and again in land use law. And it's easy to say, but it's difficult to do. And so some speculate that because the planning came after the zoning, we're still struggling with how to pair these two together. So where do we get the authority to do this? How do states and local jurisdictions get the authority to pass these types of laws? And I think about this as sort of a kick the can down the road source of legal authority. The 10th Amendment of the US Constitution says that powers not specifically delegated to the federal government are reserved for the states. So basically the states have taken this on. The federal government doesn't want to get involved with local land use law. Land use law is mostly local. And so that's how states are able to regulate how private land is used. There are some federal statutes that obviously come into play, but in general, this is where this comes from. So states have the power to pass laws to protect the public health, safety, and welfare. And those are key words in land use law. Those are police powers, as they're known, and this is really the basis for all different types of land use regulation. Oftentimes, not always, but oftentimes the state then kicks the can again down to the local governments. So in general, and this is a difficult topic to talk about for a national audience, I assume we have people from many different states on the webinar today, because land use law is inherently local. So definitely listen to what me and my co-panelists have to say today, but realize that to truly understand land use law, you're going to need to take a local look at what's actually going on in your jurisdiction. Okay, so a couple more bits from the Constitution that are, I think, important to highlight to sort of set the stage. So we've got the Fifth Amendment, and it's actually got two protections that come into play. The first is that nor shall any person be deprived of property without due process of law. And then there's a really important semicolon in there because there's a separate protection that says that private property should not be taken without just compensation. So we actually get many different protections out of this one statement with that important semicolon in the middle. We'll start with the second part, which is the takings protection. And most folks have heard of this, right? We don't expect the government to come and take our property unless we're going to be compensated for that. And takings can be physical takings, where your land is actually physically occupied by the state, by the federal government. Those are rare, and it's much more common for people to have claims about regulatory takings. And by that, I mean, a law has taken my property value away from me, or my right to use my property. Again, these can be challenging claims to make because you really have to prove that basically they've taken all of your right to use your property. But right now in jurisprudence, we're much more likely to see a regulatory takings claim. Then we have two different parts of due process, which are important to keep in mind. So we have a right to due process, and we have a right to procedural and substantive due process. So procedural due process just means we have the right to know about it. We have the right to know what's going on. We have the right to come to the public hearing, have cross-examination, have a record created, and we have a right to appeal the decision if we don't think it's a sound decision. You will see this, land use law is very out in the open. It should be if procedural due process is being honored. So you should be able to go and watch your local jurisdiction, how they make their decisions, and how approvals are granted or denied. And then we have substantive due process, and that's really about how the state can regulate and how they can restrict your rights. So you have the right to be free of unreasonable or arbitrary laws being passed, which would restrict your property rights. So to be valid, a land use law has to be pursuant to a valid police power. So it's got to be to protect the public health, safety, and welfare. And there has to be a connection between the restriction and a legitimate government purpose. This is, again, a challenging thing to claim. The government is really given the benefit of the doubt that the law they've passed is valid, and they can usually make a connection between the law and a legitimate government purpose. The 14th Amendment, importantly, gives the states those Fifth Amendment protections. So we're protected from the federal government doing those things, and we're also protected from the state doing those things. There's also an equal protection an equal protection provision in that law, and that just requires that classifications be similar. So people in the same zone need to be treated similarly. It can be a little tricky sometimes when you think about equal protection in zoning, because often in zoning we're inherently dividing people up and treating people in different zones differently, and that's okay. You just have to think about uniformity in the zone itself in each different zone. So classifications like we are used to seeing in zoning are typically okay as long as they're rational and not arbitrary. If you get into classifications based on suspect classes, so that's race, national origin, that type of thing, those are going to be looked at a lot more closely by the courts, and a test called strict scrutiny, which is, again, a difficult thing to overcome, is going to be applied, and those types of classifications are more likely to be reversed by a court. So I don't want to bore anyone with case law, but I did want to give you a little rundown about sort of the landmark case in zoning, and that is Euclid versus Ambler Realty. And you might have heard the term, and hopefully you'll understand it after today, and I know Peter's going to go into this a little bit more detail, but we call traditional zoning Euclidean zoning because of this case. So this case, 1926, an important time in zoning. After that standard zoning enabling act came about, and after jurisdictions like this town in Ohio decided to take this on and pass a zoning act which divided up land and treated people differently. The realty company in this case owned 68 acres, and after the town passed the zoning ordinance, the land, which spanned multiple districts, was significantly restricted, and they argued that this zoning action violated their 14th Amendment protections, violated due process, equal protection, basically, hey, you can't pass that law, town. That took away my property. It's not worth what it used to be worth, and I don't think I think I'm protected by the Constitution from you being able to do what you did. Supreme Court took a look and said, we disagree. As long as it's done in a non-arbitrary way, and as long as you're connecting it with those police powers, as long as you're doing this zoning to protect the health, safety, and welfare, I think this zoning in this way is a valid use of your police power. And the town was able to make that connection by saying that this was needed for public safety purposes, fire departments, decreasing traffic, improving the overall quality of life. So that case was important because after that, zoning kind of spread like wildfire, and that was the case that sort of let everyone know if you do it this way, it's legally a valid way to zone your jurisdiction. I'm going to briefly go over some of the basic tools. Peter's going to get into the more detailed tools, but some of the basic tools to understand in zoning are a comprehensive or master plan, a zoning ordinance, and then subdivision regulations. So comprehensive plans, depending on where you are, it might be called a master plan, may have a different name, but it's pretty common for a jurisdiction to have a planning document that's separate from your zoning law. It's going to be long ranging. And again, it's going to depend, maybe looking 5 to 10 years into the future. And it's sort of a roadmap for how the community wants the land to be developed. It's going to have a lot of things in it. Often it's a very thick document. It's going to provide an overview of what's going on in the area now, and then what's your future goals and objectives for development. It's going to have maps showing future land uses. Where do we want, you know, a new public transportation line to go through the town? Do we want to preserve this certain part of the town because it's in an environmentally sensitive area? It's going to have a lot of those types of things in it. It's a policy document. It's not law. However, often zoning laws and approvals, future approvals, have to be consistent with the plan. So I think folks who are trying to get their arms around land use law can get easily confused with how the comprehensive plan or master plan functions with the zoning law. They have to be read together. And it's an important thing to take a look at it, to not discount it just because it isn't actually in the law, because it is a powerful document if you're trying to amend a zoning law or get an approval. And then we have the zoning ordinance or the zoning law, and that's going to be the thing that establishes those different use areas called zoning districts. They're going to be depicted on a zoning map, and then in each district there's going to be, and again this varies, but in general, permitted uses, non-permitted uses, and then some variation that Peter will talk about conditionally permitted uses. So maybe we'll let you have this use if you come in front of a board and prove that it's not going to have impacts on your neighbor. It's also going to have provisions for controlling the type and intensity of development. So how far can you build that building back from the road? How close do you have to be? How close can you be to your neighbor? How much space do you have to give? How many structures can be in the area? Again, it's a lot of details, but it's all to balance those private property rights against the need to protect the public interest. The intent, like I said at the beginning, is really to try to separate incompatible uses. So we're going to allow multifamily townhouse apartments in this area, and then, you know, large single family houses in another area, because if you put those two uses together, the people that own the large single family houses might not be so happy that there's a huge apartment building that's being constructed next door. Subdivision regulations or a subdivision ordinance, it's really just going to outline the procedures by which you divide individual building lots. And your depending on the jurisdiction, the subdivision law might be within the zoning ordinance. It might be separately in the town or county code. It's going to differ, but this is just going to lay out how you would be able to subdivide. What are the rules for subdivision? How is the submission process going to go? The various steps. So just a few bits about land use law if you're unfamiliar with it and maybe considering it as a career path or a new area of practice. I like land use law because it's very intergovernmental and interdisciplinary. So if you practice in this area of law, you get to work with a lot of different types of people. So you get to work with developers, engineers, planners, environmental experts, become good friends with your local government staff. They're very important people in land use law. And so if you like working with a variety of people, if you like leading a team, if you enjoy a break from just working with lawyers all day long, which I think a lot of us sometimes do, it's probably a good area of the law for you. It's done, very important things are done on the local level. So it's an interesting area of the law for young lawyers to get into, or maybe folks without a lot of experience, because you can go to a local board representing your client and be involved in some really interesting and important things. Don't discount that the actions are done on the local level. As you may see, you know, the things that are done in front of a few people at the town hall, at the town meeting, can end up to be extremely important, and even a case that ends up in the highest court of the state. Here's just a couple recommended resources. If you want to keep up with land use law, there's a great blog called Law of the Land that you can subscribe to, and they send you some really interesting cases nationally. I also encourage you to exercise those procedural due process rights and attend your town or county's planning commission or board of appeals proceeding. It's open, it's free. You should be able to attend it. Now you can probably attend it virtually, so you won't even have to leave your house. And you can really learn a lot. And then lastly, consider serving on one of these boards. If you're in private practice in the area, it may create conflicts for you. So that's something you're going to want to talk to the other people in your firm about. But if that's not a concern, go ahead and see if they need people to be on those boards. They usually love lawyers to be on them, and you can really learn a lot. So thanks.
Thank you so much, Sarah, and we will now turn things over to Peter.
Good afternoon, everybody. My name is Peter Goldsmith. I work in the General Counsel's Office of the Maryland National Capital Park and Planning Commission. And the commission is made up of several constituent parts. And I work closely with the Planning Board in Prince George's County and the Planning Department in Prince George's County. And Prince George's County is one of 2 counties in Maryland that border on the District of Columbia. And our legal team advises the Planning Board and the Planning Department. I just heard Sarah talk about the Village of Euclid case. The general takeaway there is that Euclidean zones are rigid, and so an example of a Euclidean zone might be a residential zone, and in a residential zone, what's going to be there? Residences, and there might be other uses that are that serve those residences, like school or perhaps a religious institution, but generally what you're going to see in a residential zone are houses. Other types of the classic Euclidean zones are residential, commercial, and industrial. You may also see, depending on where you are, in agricultural zones, which may include farms, equestrian facilities, or animal keeping. I worked in a law firm before working for the commission. I worked for a law firm in Annapolis, and in Annapolis and around Anne Arundel County, where Annapolis is located, there's maritime zones, and in those zones you might see a marina or boat storage or yacht club or sailing school. And then in open space zones, you might see parks or conservation areas. But again, the general takeaway that Euclidean zones are very rigid, and they should be contrasted with mixed-use zones and floating zones, which I will talk about as well, which add a lot more flexibility. Now, here's an example of what you might see in certain jurisdictions that are depending on where you're located. Your residential zones might be named something like this, like a rural residential zone, which would might have one house per 20 acres. You might have single-family detached zones, which are exactly what you see in this picture, or a single-family attached zone, which are townhouses. And these pictures are taken from in Prince George's County. They are going through a rewrite of the zoning ordinance, and the county council just passed a brand new zoning ordinance, and they have images in the code. And so I borrowed some of the images in there because I think they really they illustrate a lot of these points very well. Now, here's an example of a commercial zone. The names of commercial zones might be commercial shopping centers. So what's going to be in a commercial shopping center? It's going to be a shopping center. So it might be some retail or a grocery store. You can see a commercial office or a commercial neighborhood. These zones might also be called C1, C2, or C3, depending on where you are. C1 might be a commercial light zone, or something akin to the commercial neighborhood zone, where you could see like coffee shops. And a C3 zone is a little bit more intense, where you could see auto service shops, and that could let's see. Here's an example of an industrial zone. In the industrial zone, you might see warehouses, or for example, in a heavy industrial zone, you might see wastewater treatment plant facility, or their factories, or generally the sticky stuff that Sarah mentioned. Maybe in a light industrial zone, you might see an Amazon fulfillment center that's going to have trucks running 24 hours a day. You want to keep that stuff away from the residential zones where people are sleeping. Then there are mixed-use zones. These might be named the mixed-use transit-oriented zone or town activity center, downtown. This is something that you'll see usually, typically in an urban area. You might see an apartment building with some retail downstairs, or an office building with a restaurant downstairs in these zones. Now, as you can see, Sarah kind of gave you a 1,000-foot view. I'm going to give you kind of a little bit a real practical, lead a practical discussion and show you kind of like how these concepts are used in the real world. Sarah mentioned some of the other regulations that a zoning ordinance might have in it. Not only does it regulate uses, and by uses I mean how property is used, they will also regulate how a site might be designed. For example, how far a building can be set back from a property line. So for example, this is taken from the Anne Arundel County zoning ordinance in the R1 zone, where a house can only be no less than 15 feet from the property line. So in the R1 zone, which is about 1 house per acre, give or take, houses will be 30 feet apart. Now, in certain instances, property isn't, every piece of property is not going to be a rectangle, and every piece of property is different. And so there has to be some type of relief valve here to allow people to develop on their property. Otherwise, it could be a regulatory taking. So one of those relief valves are variances, and variances might allow a property owner to build a house on a property with a little bit less setbacks than is allowed. For example, let's say you bought a house you bought a vacant lot in a residential development that was built in the 60s, and because for some reason or another, maybe because the lot was so narrow, that lot never got developed. And back in the 60s, the zoning code might have been for 50 pages, and now it's like 1,000 pages and highly regulated. And so if you want to build a house that conforms to the neighborhood, you want to build a house that looks like it fits, and not one of those, not like a mini house. You're going to have to build it and maybe within that setback requirement. And so what you would have to do is you would go before either a zoning hearing examiner or an administrative hearing officer or a board of appeals, or depending on what jurisdiction you're in. It'll be in a room that kind of looks like a courtroom, and you'll have to present a case and explain why your property is so unique that you're entitled to build on the house in a way that doesn't exactly conform to the zoning ordinance. And there are other types of relief valves. You may, from various parts of zoning ordinance or subdivision regulations, they might be called variations or modifications or departures. For example, like you might need a modification from forest conservation law where you're planning to build a gas station on a forested property, and you have a specimen tree located in the exact spot where the only access could be located. And so you might have to explain to the planning board why that specimen tree has to be removed. Sarah mentioned this as well. So you have there are different types of uses. You have permitted uses, which are they're unquestionably should be permitted. You really don't need a hearing. Like for an example, if you're building a single-family home in a residential zone, the only approval you're going to need are building permits. But let's say you have a use that requires a little bit more scrutiny, and there's going to be a little bit more impact, and might require a public hearing. And so, yeah, it's presumptively compatible with the neighborhood, but it would require you to satisfy certain conditions. So, for example, let's say I own a 50-acre property in a residential agricultural zone. And in my backyard, I want to build a kennel to train hunting dogs. And that in a residential agricultural zone, that you'd think that something like that would be okay, but there's some it might require a little bit more scrutiny, because you could have dogs barking all night, and there's people living next door, and so you might have to present your case to the zoning hearing examiner. And you'll have general conditions that you have to meet which are applied to every special exception or conditional use. And these uses are called different things in different areas. Here, they could be a special exception, they could be a conditional use, or they could be a special exception conditional use. And so there could also be specific standards or standards specific for that particular use. So for the kennel, for example, not only would you have to meet the general standards, show that it's not detrimental to public health, safety, and welfare, conforms with the general plan. You might have to show that, look, I'm building this on a property that's greater than 5 acres, and that it's within 100 feet of my neighbors. You might even want to bring a noise expert in just to solidify your case and show, look, this building's going to be fully enclosed, and it's not going to generate any noise. I'm going to bring one dog out at a time to go for a walk. And if you don't have any opposition from your neighbors because you did a good job and you walked around and spoke to them, told them what you were doing, generally the administrative hearing officer might approve your special exception, and then you can move forward and get your building permit. This quote in here is from a case. It essentially says a special exception is neither a special nor an exception, which is probably true, but I think they're really special cases. It's special because they really bring out a lot of opposition, and they're fun cases. Variances are a little bit different from special exceptions. Special exceptions are presumptively they're contemplated uses, but they just require just a closer look. Where variances are complete departures from what's allowed, but again, they're just a relief valve to avoid confiscation of property. So how do you know what type of use you have? In a typical zoning ordinance would have a table of uses, and you just kind of look at the chart, and here you see single family detached, it's P, permitted in all of these zones, and there's our commercial kennel. It's a special exception in that residential agricultural zone. And then if you see a blank, that means it's prohibited. And there's a case in Maryland where a judge analogized the use table and the sorting of uses like the sorting hat in Harry Potter. And if you're not familiar with Harry Potter, if you on your first day at the Hogwarts School of Witchcraft and Wizardry, the professors set you down on a stool and put this enchanted hat on your head, and the hat somehow uses some formula to figure out which house you deserve to be in. So like Harry Potter and all of the good guys in the movie end up being in Gryffindor. There's other houses, Ravenclaw, Hufflepuff, and then all the terrible kids end up in Slytherin. And so here, the legislature is placing the sorting hat on each use and scrutinizing whether it's a permitted use, whether it should be a permitted use, and it fits that zoning district, whether there needs to be a little bit more scrutiny and it should be a special exception conditional use, or whether it should be prohibited. Now, I spoke a little bit about opposition. Depending on, typically in an administrative hearing, meaning like before a zoning hearing examiner or planning commission, there's really not, you don't need to meet a high bar to just show up. You just put your name on a list and you can get up there and say, just about anything. You'd have to kind of keep it generally relevant, but depending on the board, they might just let you talk about anything you want. But the standard is a little bit different. In Maryland, you have to be a person aggrieved, and it's kind of a term of art here. So you generally have to be within a 100 or within 1,000 feet of the development that you're challenging, and you have to be aggrieved in a way that might be different from the general public. So like complaining about traffic is not going to cut it. So let's go back to that example where we were talking about building a kennel in your backyard. Let's say 10 miles down the road, there is a dog grooming, a dog groomer that doesn't like the idea of a kennel being built nearby, and they're worried about competition. Now, of course, the dog groomer, because they're 10 miles down the road, they probably won't have standing because just general competition is not going to be enough to get you into court. But let's say they decide to call up all of your neighbors and fund and pay them to oppose your development. Those neighbors would have standing because they live next door. They will be affected by the traffic coming in and out of your property, the dog owners bringing their dogs back and forth, and also the barking. So it's always a good practice to go talk to your neighbors first before you file any development application. Other types of zones, or another type of zone is an overlay zone, which would modify the regulations in the base zone. Now, for example, you might be in a commercial zone that allows a 20-foot, might allow an office building that's 20 feet, but might be an aviation policy area where there's a local airport. And so because you're in that overlay zone, the maximum height of your building might only be 5 stories. If this picture shows the critical area of the Chesapeake Bay around the city of Annapolis, which is around the Chesapeake Bay is a very environmentally sensitive area, and so there are additional restrictions for development on and around the Chesapeake Bay and its tributaries. I'll talk a little bit about rezoning. Now, Sarah talked about, in the beginning there was no zoning, and then at some point most jurisdictions have enacted zoning ordinances. Some still don't have zoning. The first zoning ordinance in your jurisdiction would be original zoning. I'm going to talk a little bit about comprehensive zoning, piecemeal rezoning, and text amendments, which are not exactly rezoning, but similar. Comprehensive zoning, Sarah talked about how your town or county, municipality may have adopted a comprehensive plan. And where I am is in Prince George's County, the council adopted a comprehensive plan. It looks something like this, Plan 2035, which lays out their plans for the next 15 years and what they want to accomplish. And then as part of that process, they're also rewriting the entire zoning ordinance. The zoning ordinance has been around for 40 years. It's become really unwieldy. They are going to consolidate 74 zones into 43 brand new zones and rezone every single property. Now, this is a chance where you might be able to write a letter or submit some type of application to the legislature and try to get your property rezoned in a way that might benefit you and increase the value of your property. Another way that your local jurisdiction might allow you to rezone your property is by a piecemeal rezoning or a zoning map amendment. And here, in order to do that, you have to satisfy the change mistake rule. And essentially, you have to prove that there's either a substantial change in the neighborhood since the last comprehensive rezoning, or that the legislature just made a mistake in the zoning map. Now, how this might work is, for example, let's say you own a wedding venue. Okay, you bought it right after the last comprehensive zoning, and you bought it in this little neighborhood we're going to call this, there's just a few lots in this neighborhood, for example, just using this for an example. And you bought this wedding venue. It's right next to a really tiny, it was next to a really tiny marina, next to a vacant lot, next to a guy named, a guy named Stu lives in one of the houses, and there are a couple other second homes, and then there's open space with nothing there. And then over the next 5 years, your wedding venue is really successful, and you want to expand it, and you want to buy up that vacant lot next door. But unfortunately, that vacant lot is zoned R2 and doesn't allow wedding venues. And so you want to buy that property, but you want to rezone it. And so in order to do that, you have to prove that there was a substantial change in the neighborhood in the past 5 years. And let's say in that 5 years, that marina has doubled in size. It built additional piers and mooring buoys, and now there's twice as many boats there. Somehow Stu had a friend on the liquor board and a really good lawyer, and was able to obtain a commercial liquor license to open up a bar in his basement. And those single family homes are now listed on Airbnb as short-term rentals, and that open space is now a commercial campground. So now what used to be a little sleepy neighborhood is you see where there were just a few cars driving down that road. Now there's this highly trafficked area. So you might be able to just go before the planning commission, that zoning hearing examiner, and make your case to show that there was a substantial change in the neighborhood, that you can get that vacant lot rezoned and expand your wedding venue. Another thing you might do is with an old zoning code where they didn't contemplate certain uses, where the internet may not have even existed, you might need to add a use to the use table. For example, let's say you're sitting in your law office and you get a call from somebody who wants to open up or start an online sale, a used car dealership, and but this property is in a commercial light zone that doesn't allow used car sales, so you have to get creative. And what you may want to do is you call up your local county council person and say, look, this is going to bring a new business to the area. This is very different from the impacts that a used car dealership might have. There's no inflatable tube men outside. You don't have all the neon flashing signs. You don't have obnoxious salespeople. This is just an office and a parking lot where somebody orders a car online, they process it, and then they just ship the car off. So there's very little impacts. And the local county council person might introduce the bill to the county council or the town council, and they might add the use into the use table. Next type of zone is a floating zone, and these are a little bit more complicated than standard Euclidean zones. And what the purpose really is to just add add flexibility that a Euclidean zone may not have. And for example, something like this, a floating zone doesn't exist on a zoning map. You have to apply for it, and then, like if I owned a commercial piece of property on the water and I wanted to open up a tourist destination, I might want to apply for one of these floating zones, and they could be called you might see them called a comprehensive design zone, or a planned development zone, or a major activity center, or something like that. You apply for this major activity center, and in your application, you say, look, I want to build some hotels. I want to build a casino. I want to put in a Ferris wheel. I want to put in some public spaces. But in exchange, I will add some public benefit features like a promenade, maybe a community center, a cultural center, a library, and the planning commission or the legislature might look at the balance and say, okay, well, this makes sense for this particular piece of property, and they might allow you to rezone the property with the floating zone. some uses may have been lawful at one time, and then they are no longer lawful. So let's say, for example, you have an international food market that was open in the 50s, and it's been and ever since then it's been in the same family. But since then, in the 50s there was no zoning ordinance, but now, but since then it's been there. The zoning ordinance has been enacted. It's gone through a series of comprehensive zoning, and now it's located in a residential zone. But this international food market, which everybody loves because there's a little grill in the back, and it's a place to shop for food that you can't get anywhere else. But now the grandkids want to renovate the property, but in order to do that, they have to go in and get a permit to renovate it. So they may go to the planning department and say, can you certify this use in order for us to show that, just so that way we can move forward with our renovation. And in order to do that, they would have to somehow prove that this use was lawful at the time in the 50s. There might be photographs of their grandparents working in the food market from the 50s, or there might be aerial photographs. You might be able to submit bills. You could call witnesses that maybe lived in the neighborhood back in the 50s and have been shopping there for 70 years. And if you can prove that before the planning board, they might agree to certify your non-conforming use, and then you can go get your building permit to renovate the international food market. I'm getting close to running out of time here, so I'm just going to wind up. I just want to talk briefly about land use exactions. These are kind of the three primary cases. I'm not going to get into that. You can read them yourself. But the general principle here is that if you build something, you're going to make an impact, and the government can ask you to mitigate that impact to an extent. And the general principles that you can extract from these three cases is that mitigation, there must be an essential nexus between the mitigation and the impact of your development, and the mitigation that the government is asking for must be roughly proportional to that impact. Now, typically, what you see is, let's say you're building a 100-unit subdivision, and so there might be some type of traffic calculation, and you might have to upgrade an intersection that doesn't have a traffic signal. You might have to install a traffic signal. But let's say, for example, you have a town center, and then there's one property on the edge of the town center that isn't developed. And then between that town center and that undeveloped property is an interstate highway, and then on the other side of the interstate is a mall that's dilapidated. It had a bunch of retail stores that have now gone bankrupt, and the mall is kind of losing tenants. And it's not really your fault that they planned, or the jurisdiction planned to have this town center and the mall bisected by an interstate highway. And so let's say a luxury or a grocery store wants to come in and develop that undeveloped piece of property in this town center. And the Office of Planning and Zoning says you can't do that unless you build this 5 million pedestrian walkway over the interstate to connect to that mall. That, of course, is not roughly proportional to the impact of the grocery store. And now, if the planning and zoning department insists on it, that parcel may never get developed. And finally, this is my last slide. There are other types of private restrictions on land, and there may be a reason why you want to place a covenant or condition or restriction on land, and these are obligations and deed burdening that may burden or favor a landowner. For example, if you have a golf course community, you're developing a golf course community, and the developer builds. You have houses in there, and then the developer sells the golf course to a golf course operator. Now, the golf course operator, you may want to have a covenant recorded in land records that says if the golf course operator ever goes out of business, the ownership of the golf course reverts back to the homeowners association, and that way the homeowners would be protected because they bought in there to have the golf course and the nice green open space rather than having the golf course operator go out of business and then sell it to another developer who might develop those the golf course holes and build houses on there. And they're also this is going to get into Emily's kind of transitioning to Emily's presentation. There are other types of easements that you might be able to place on property: conservation easements, agricultural preservation easements, historic preservation. In the city of Annapolis, where I used to work, there the Historic Preservation Commission has rights on your to inspect your property and make sure that you're not tearing down any historic homes. You can have view shed easements here in Maryland. The owners of Mount Vernon buy up property rights across the Potomac River to prevent certain types of development from going up. For example, really shiny buildings or buildings that are really tall. They want to preserve that view to make it to keep it the same way as it was when George Washington lived there. So I want to thank you again for your time. If you have any questions, please, you can email me. My name is Peter Goldsmith. You can email me at peter.goldsmith@mncppbc.org.
Thank you so much, Peter. We will now transition over to Emily. Thank you all so much.
All right, thank you. I put a lot of pretty pictures of land in my presentation, so I hope you enjoy it. Shifting gears, Peter, thanks for the good segue into talking more about land conservation and private land restrictions. So I'm Emily Parrish with the Land Trust for Tennessee. We are based here in Nashville with an office in Chattanooga. I'm going to talk more generally about land trusts and then dig into conservation easements specifically, which is what we use the majority of the time to conserve land across the state. So what is a land trust? They are all a little bit different, but typically it's a private nonprofit organization with a mission to conserve land or water resources, some sort of natural resources. Not to be confused with other kinds of trusts. That's very common. You hear, we call ourselves land trusts. It's very different than a family trust or that kind of trust you might set up, privately. So just to clear up that confusion, most land trusts work directly with private landowners to help them achieve conservation goals, and that can be a variety of things. And ways that we work with those landowners. We also sometimes work with governmental entities and municipalities and state governments, but I'm going to focus a little bit more on the private landowner side today. So there's approximately 1,700 land trusts across the country. They're all different, and I like to use an example. Here in Tennessee, we probably only have about 10 organizations that would fall under the land trust umbrella. We have some that focus on one town. We have one that focuses on one river. And then you have people like us who work all across the entire state. I like to compare us to Connecticut, where there are like 170 land trusts. So where the land trust movement really started in the Northeast, a lot of those little land trusts may have formed as a volunteer organization or to protect one piece of land in one town. So in some states in the Northeast, you see everywhere you go, you see a different land trust, and it's a very different model than what has happened as it has spread across the country. So you'll see statewide land trusts and then very tiny land trusts, and we all kind of fall under that land trust umbrella. Most of us are members of the Land Trust Alliance, which is a great organization in DC, but they provide best practices. They lobby on behalf of the land trust community if that's necessary. They put out standards and practices, which are technical and ethical guidelines to running a good land trust. And then about 10 years ago, they went a step further and started an accreditation program. So now land trusts can go beyond just adopting the standards and practices and go through accreditation. And so there's about 500 or so land trusts now that have gone through that accreditation. I just submitted our 3rd renewal for accreditation. So we just finished up that process. We do that every 5 years. So, you know, like any nonprofit, land trust work is first and foremost guided by your bylaws and your charter, your mission statement, and then, you know, a board of directors that helps guide the work and makes decisions and is the fiduciary agent for the organization. Most land trusts have a strategic plan. We actually have 2 strategic plans. One is our just organizational strategic plan that covers a variety of facets of the organization. But then we also just recently completed a strategic conservation plan. So that is where we spent a year really deep diving into data and mapping and a lot of other things to come up with where are we going to do our project work. So what's our strategic direction? And where do we want to do our work, which is really important for a statewide land trust like us, where we could work anywhere across the state. So it helped us hone our focus in doing that strategic plan. And then land trusts will just have certain conservation priorities or values that they care about. There's land trusts that just focus on agricultural lands, for example. Some, like you think of the Nature Conservancy, they're a type of land conservation organization. They focus mostly on biodiversity and habitat. So land trusts tend to have sometimes their own conservation priorities and values that they focus on. So for us, just to give you an example, again, we're a statewide land trust, which Tennessee is a quite large state. We have 96 counties, so it's a lot of work. But our mission is pretty broad, but we conserve the unique character of Tennessee's natural and historic landscapes and sites for future generations. We are one of the few land trusts I've ever seen with the word historic in our mission statement. So we do have a focus on historic landscapes. We also protect a lot of working farms, even though that's not quite as reflected in our mission. We are the only land trust in Tennessee that focuses on farmland. And here's just a quick map of where we've worked over the years. You can see focused in Middle Tennessee, and then we have an office in Chattanooga in the Southeast region. So we have some projects scattered around there. We've done over 400 projects, and the vast majority of those are done through conservation easements, and that's what I'm going to focus on. But land trusts can protect land in a variety of ways. So just like I talked about the size and the priority areas, land trusts protect land in a lot of different ways. Some land trusts just own and manage land, like a preserve. They almost treat it like a park. It might be a property that's open, with trails and the public can come on it. Some land trusts like us focus a lot more on private land conservation. So that land remains in private ownership, but is restricted with the conservation easements. And that can still very much limit public access. It's just like the landowner would be today. The public would not have the right to go on those properties just because it's conserved land. So land trusts typically focus in these types of tools. Again, I'm going to focus on conservation easements. Those can be done through purchase, where the landowner is receiving cash in exchange for doing a conservation easement. They can be done through donated, so the landowner is voluntarily giving away certain development rights on their property. That can be done in exchange for tax benefits. I'm going to talk a little bit about that. Or a bargain sale is a combination of those. So the landowner is selling certain development rights, but they're getting some cash in exchange, but they're selling those below fair market value and might get some donation as well. So a bargain sale is a combination of those. Land trusts sometimes acquire land through a direct acquisition. So a purchase, land might be donated to a land trust for them to own and manage. Again, The bargain sale can come into play. A land trust might buy land below fair market value. That would be a bargain sale. A bequest. This happened to us a couple of times. Land is left to us in someone's will or estate. We actually own a 65-acre farm 4 miles from downtown Nashville that was bequest to us as an organization. It's actually where our offices are located when we're in our offices. And then there's situations where you combine tools. We have landowners who have done conservation easements with us and then turn around and sold that land to the state to become a park. Sometimes they're putting that extra layer of protection before turning it over to a governmental entity, just to make sure that that land is used how that landowner desired it to be. We have landowners, again, who have done easements with us, and they plan to leave us their land in their will. So combining some of those conservation tools. And then a lot of what we do is behind the scenes. I would call it assistance or facilitation. Sometimes all we're doing is helping property get into some sort of public protection, a park. It is sometimes challenging for a landowner to sell or give land to one of our governmental entities. So sometimes we're just playing the intermediary third party just to kind of help facilitate that project along. And at the end of the day, we don't end up with any property interests, but we've helped get that land into some sort of protection. So sometimes we play that role as well. So I'm going to focus on, there we go, conservation easements. So I call it the landowner's tool because it is one of the best things a private landowner has the best option of doing to conserve their land while still maintaining ownership of the property. And it is our primary tool for conserving land. Here in Tennessee, we have very, very limited conservation funding. So we are doing almost exclusively donated conservation easements. And I'm going to talk about how those tax benefits work. It really depends on your state. Some states have very robust programs. Some cities and counties do to buy conservation easements from landowners. We are just unfortunately not in that situation here in Tennessee, but very state dependent on what kind of funding is available, or city or county dependent. So a conservation easement is a real property interest that's established through a voluntary agreement between a landowner and the holder. The holder in our case is a land trust, but it can also be at times a governmental entity, city, state, occasionally federal holders. So that it's just a agreement between those two parties. The goal of a conservation easement is to permanently limit development on the land in order to protect its conservation values. And there's a variety of conservation values. Here are just a few examples. It can be, as Peter talked about, like scenic, viewshed type easements, agricultural lands to preserve working lands. I mentioned historic. So if you wanted to preserve land around a historic structure or a site, we've done a fair amount of properties that involve paths of the Trail of Tears. So properties that have some historical or cultural significance, natural habitats, watershed protection. Some of the best examples, in the Hudson Valley is to protect land for the watershed of New York and Manhattan. Was done. A lot of that's done through land conservation. And then there can be public recreation or education on our more public type properties. So on the other side of this, that was a little more general definition. Here's what the Treasury regulations describe as a qualified conservation contribution. So this is defined if a landowner does want to qualify for any of the tax benefits of doing a conservation easement, they have to meet these regulations. And the IRS has been very involved in scrutinizing a lot of these transactions lately. So any landowner that we work with, we make sure they have good counsel, they have a good appraiser, they have good advisors, because they are being more and more scrutinized. So to qualify for those deductions, the definition in the Treasury regulations, it's a qualified real property interest to a qualified organization exclusively for conservation purposes. And so there's a definition in the regulations about what is a qualified organization, what is a qualified real property interest. I just didn't want to bore you guys with all of that. And then it goes on to define what is conservation purposes. For a landowner to receive any benefit, these have to be perpetual restrictions. So that is, I know a lot of law students immediately are confused because you hear about the law against perpetuities and all these things. Well, conservation easements are the one really exception of something that's intended to last forever. And so we write these documents assuming, you know, forever. Now it's really hard, obviously, to wrap your head around, but think way out into the future as far as you possibly can. And that is what we're trying to do, is write these in a way that they are going to last forever. So there are some easements that are term, you know, 20, 30, 50 years. But if you want to qualify for any sort of benefit, they need to be perpetual. Most land trusts I know really only accept perpetual easements anyway. It doesn't really help us meet our mission if we are only going to do it for 20, 30, 50 years. So the IRS, the Treasury regulations go on to define what the conservation purposes are. And so while I listed a bunch of different ones on the previous slide, this is really in the code. You have to meet one of these conservation purposes. So it can be public recreation or education, the protection of relatively natural habitat for fish, wildlife, or plants, or similar ecosystems. You can tell that the Treasury regulations were not written by conservationists or scientists, so there's some interesting language in here. The preservation of open space, so that's where we fit farmland and forest land in. But to qualify, it has to provide a scenic benefit to the public. So again, you have to have public road frontage, or maybe it's visible from a river that people navigate, or a trail system, but you have to show some scenic public benefit for that open space land. Or you have to have a clearly delineated governmental policy you can fall back on. So if your town or county has a really extensive comprehensive plan that has gone to identify certain areas or even certain parcels of having open space or, you know, conservation value, you can rest on those types of specific governmental policies to help your property qualify under open space. And then also a landowner could qualify, a piece of property could qualify under historically important land area or historic structure. I'm going to ignore structures because that's a totally different kind of easement called a preservation easement or a facade easement on an actual structure, but they do qualify under this section as well. So for us, if we're going to use historic, the area needs to be, you know, on the National Register of Historic Places, maybe a battlefield that's been identified by, you know, the National Park Service is important. You know, we have to have some real historic designation for it to qualify under that section. So the biggest misconception I think out there, at least that I run into, is people think, oh, they gave their land to the land trust. And in our case, in the case of a conservation easement, the landowner maintains ownership and management responsibility. So the landowner, they're entering into this conservation easement, but in most cases they can, you know, still live on the land. It can be private. They can still post no trespassing signs. Even if it's visible to the public, it does not mean the public can go on the property. The property can still be sold. It will just be sold with the conservation easement intact. It can be passed on to their children. It can be given to the local church, but it's going to be passed on with those restrictions in place. And so we run into that a lot. People think these landowners have given up their land, but no, they've just restricted it. So a conservation easement is going to limit the development on the property. I'm going to get into a couple of examples that'll help describe how we do that. It will limit the ability to divide the property. So we typically restrict the property needs to stay intact as it is today, or it can be divided 1 or 2 times, but it's never going to be intensely divided into a subdivision or some other type of use. It will limit certain uses on the property. For example, our landowners are giving up the right to mine. That's a right they've given up. They are giving up some of their timber rights. We do allow a lot of our landowners to still manage their timber, but they're going to have to do that subject to a forest management plan and with best practices in mind. We also don't allow our landowners to do any sort of high density agriculture, so no feedlots, no chicken houses, the big ones I'm talking about, you know, that industrial level of agriculture. So we are limiting some of the uses on the property as well, but most other uses are fine. You know, farming, hunting, recreating, you know, really how that landowner's likely already using their land today. A lot of those uses continue under the conservation easement. In these agreements, they also are giving the land trust certain approval rights. So a lot of activities might be explicitly permitted with the approval of the land trust. So landowners, if they reserve the right, let's say, to build a future residential structure, they reserve the right to do that in the document, but they aren't going to actually start construction until they've gotten specific approval from the land trust. So a lot of things are rights they've reserved, but there will be a trigger before they actually start to use those rights. And it gives the land trust approval and oversight of some of those. There's also just areas where we have to be notified of certain activities, not an approval standard, but we need notification. So there's levels of land trust involvement throughout the document. So landowners have a lot of benefits. Customization is one. These are specifically tailored to the property and the landowner's goals. So we work months, sometimes years, with a family to customize these agreements and work through them together. None of them look exactly the same. They're also customized to protect those specific conservation values on that property. Landowners can phase these easements over time. So the woman that was in my photograph with the mission statement earlier, she's protected 100 acres with us now, but she has 30 acres in her will to be added upon her death to the conservation easement. So she did that as a phased. This is a voluntary choice. I'm never going to force a landowner to do a conservation easement. It's just something we work through together, and it's totally a choice. It's an alternative. I say it's an alternative to any other type of use you want to have for your property. So if you decide to sell your property for development, that's a choice as well, but this is an alternative to that choice. It can be done post-mortem. So occasionally landowners specifically write something into their will that they want a conservation easement done upon their death. Occasionally executors can elect to do conservation easements as part of settling an estate. And I won't go into all that because that's a whole separate section of the law, but landowners do have the rights to do them post-mortem. And then most of our landowners do this because it's permanent, peace of mind. They love their land. They don't want to see it change or be developed when they're gone. And this is a tool for them to make sure that their wishes and goals stay in place forever, even when the land changes hands. Obviously, the tax benefits can be icing on the cake, but I would say most of our landowners we work with are first and foremost doing this because they care and love their land. And then some of the other benefits are secondary to that. It's our job to monitor and enforce the easement. So every year we send our team out onto the ground to monitor these properties, which for 400 properties now, it takes a lot. It takes pretty much all of our staff and 20 trained volunteers. We divide it up to get boots on the ground every year on every property. Right now, our goal really is to just maintain good relationships with our landowners so that we know we have a good open line of communication. We don't want to be seen as the police or the enforcers, even though technically we do have the right to legally enforce the easement if it's being violated. But our first goal is to have a good open relationship with these landowners so that we can avoid, hopefully, issues of enforcement and violations. So quickly, I'm going to go over the tax benefits. So this is just a very basic example, not giving tax advice. Everyone's situation is different, but very basic example. This couple, Jane and John, they have an adjusted gross income of $80,000 a year. Again, I'm totally making this up. They own a 200-acre farm. So they do a conservation easement. An appraiser is hired. That's who values the conservation easement, not the land trust. It's not our job. It's not the landowner's job. You hire an independent appraiser that is qualified to do this kind of work. They value, let's just say for this example, they value the land at $800,000 before. After the easement's in place, so once it's restricted to maybe 1 or 2 future homes, farming, recreation kind of uses, it's $500,000. So it's the difference between those two numbers that is really the value of the easement, the value of those rights they've given up. So this $300,000 is applied to that adjusted gross income as a tax deduction. This is federal tax deductions in our case. There are some states that have state level tax benefits. We don't have income tax in Tennessee, so I only deal with federal, but there are states that have additional benefits. So this can be applied to their adjusted gross income the year of the gift, and then it can be carried forward for up to 16 additional years. So here is how that would work. So they have a $300,000 tax deduction. A regular average couple can deduct up to 50% of their adjusted gross income each year. So they would be able to use $40,000 of that $300,000 each year and carry that forward. If they're a full-time farmer, which is less and less common, but full-time farmers have a different benefit, and they can deduct up to 100% of their adjusted gross income. So that farming couple could use up to $80,000 of their deduction each year, and then carry it forward until they hit that $300,000 total that they have available. Very simplified, but that is how that deduction can really help offset some of, some income and create a really nice tax benefit for people. I know this is not a tax class, so I'm going to keep it very simple. Similarly, if a landowner is selling an easement, so I mentioned some places there might be cash available to actually purchase those development rights. So same thing, an appraiser would come in and value that. Let's say the easement is worth $300,000. That landowner is going to receive $300,000 in cash. And they have done the same thing. They've entered into this conservation easement, but instead of getting any sort of tax benefit, they've gotten the cash value. And that happens in some governmental programs. We do occasionally. The only time we regularly purchase easements is when we're working with Fort Campbell. Our Army base here in Tennessee has a purchased easement program that comes through the Department of Defense. So in that one little area of our state, we are able to offer cash to landowners to conserve land. Totally state and local dependent. And then the bargain sale I mentioned, here's an example. Again, that easement's worth $300,000. In this case, the landowner is going to take $200,000 in cash and then take $100,000 as a tax deduction. So that's where they're combining the donated and the sale, and that's called a bargain sale of a conservation easement. And that's pretty common. Land trusts don't always have the full amount of cash, and they can only offer a landowner partial purchase, so that would be a bargain sale. Pretty common way that land trusts protect land. So I'm gonna speed up. I'm gonna give you 3 examples of some properties we worked on. This is a woman who protected her farm not far outside of Nashville. very simple conservation easements. So I'm kind of run through 3 different ones. This had primarily scenic, agricultural, and open space value. And so very simple. Let's see if my mouse will show up. Yes. So she had an area with existing structures. So we set up what we would call a homestead area. So around her existing residence, we set up about a 3-acre area here where she can build a garage, she can expand her house, she can have barns. That's really her area of activity that's established in the easement. She also reserved the right down here in the corner to do a future residential area. So at some point in the future, she can establish a 2-acre area to have another home, garages, pools, sheds, whatever might be around a residence. She can also build agricultural structures on the property, but with permission of the land trust. She can continue to farm. She can manage this forest, but we ask her to get a forest management plan with a forester and submit that to us for our approval. And then she can divide the property one time here along the road. So somewhere down the road, we could end up with 2 properties with 2 different owners, but they're under the same conservation easement. That has already started to happen to us, but that's what happens when you end up with those division rights. One that's a little more complicated. In this case, we worked with a developer. He'd owned the land for about 10 to 15 years. Eventually, it had planned to develop this property. It had been approved for 27 additional home sites. And instead, he decided to put this under conservation easement and make it a nice open space amenity for the homeowners in the area. This is an area that has a very strict zoning code regulations. We don't have that in all of Tennessee, but this is a community right outside of Nashville called Brentwood. You can see what was happening in this area. It is intensely developed. It's about 15 minutes to downtown Nashville, so it's a very affluent community. So open space is a little bit hard to come by in this area. So our big conservation values were open space. We did have governmental policy encouraging open space and actually, some nice habitat left because it was a hardwood forest intact. It's also one of the highest hills in the whole community. And so that's where some of the zoning came into play on this one. This community does have a pretty strict hillside protection ordinance. So we don't always have to work that closely with our governmental entities. It just depends on the local zoning code. Some of our counties don't even have zoning, but this one, we worked closely with them to make sure these future home sites would still meet the zoning ordinances, the hillside protection. So we actually incorporated some of that language directly into our easement. We don't always have to do that, but so in this case, again, I said they had been approved for 27 home sites. They decided to restrict the property down to just 2. And the easement sets out 4 choices, and the owner will eventually just choose 2 of those to develop. So 4 choices, 2 future homes. They can do forest management. This one has a fair amount of park type language in it because it will be likely used somewhat by the public for trails and recreation. You can divide this property one time. Developers have to be really careful when they're doing conservation easement. There's definitely some pitfalls for them. One is that they can't just conserve non-developable land. So they can't take all the best development land and then say, I'm doing this great thing, I'm going to conserve the rest of this property. There's really not any sort of tax benefit for that because they aren't giving up anything. This land already is basically unusable for development, so you're not really giving up any development rights. So that happens a lot. We get calls and then we learn, oh, the land's completely in the floodplain, or oh, this land doesn't perk. It's just not developable. So land developers also have to be worried about that there's no quid pro quo. So they can't be doing a conservation easement in order to get approval or a permit or get their plan passed through the local, subdivision regulations. There's also no donation there. they're using it, as an exchange to get what they need in their development. So developers also have to be careful that there's no governmental approval required for them to do this sort of conservation easement. So then I have an active project. I'm going to try to be anonymous as possible, but it's a very interesting one in an urban area that's intended to become a public park. So the landowner wants to put the conservation easement on the property and then transfer it to a municipality to become a park. So there's a lot going on. This is a historic property. It's on the National Register. There's a lot of open space and scenic value because it's right in the middle of an urban area. And it's public recreation will be obviously a value once it becomes a park. But we have a lot going on this property already: residential uses and structures, agricultural uses and structures. It was an active horse farm, so there's a very large stable. And there's some very beautiful scenic areas that we didn't want to disrupt. So in this case, we set up build and no build zones. We don't always do it this way, but because of this type of property, you can see it's completely developed around it. So we set up this buffer area where nothing would be built other than maybe trails and walking paths. And that's to protect that scenic character. This property is completely visible from this road and this road. So we set up a pretty large homestead farmstead area because there's already a lot of structures in that area, including a home and multiple agricultural buildings. The rest of the property we designated as open space, and that means in our case only agricultural structures or recreational structures would be permitted, like gazebos or that sort of thing. But this is a much more restricted part of the property. And then you'll notice this area is going to be retained by the landowner. So this is her private property. So that's why it's a grayed out area. But that's just to show you that, again, we tailor these things to each specific situation and the goals of the landowner. Okay. So stewardship is what we call everything. After we've signed the easement, it's been recorded at the local register of deeds. We move into our stewardship phase. So I already mentioned monitoring. We also, again, if we find a violation to the easement, we work with the landowner to try to remedy that. Enforcement actions can, go all the way to court. We hope we can solve those out of court if we can, but we know that that's our future. Part of our stewardship is what I mentioned, approving activities. So a landowner has retained the right to build an additional home. They're ready to do that. We work with them to make sure it's in the right location, that they've established their building area. So that takes staff time and a lot of review and approvals. Sometimes those have to go through our board if they're unclear or need additional information. We interpret the easement a lot, just answering general questions from the landowners. Am I allowed to do X or Y? And sometimes if that's not even going as far as approving an activity, it's just answering basic easement interpretations. And then unfortunately, we've been dealing a lot more lately with condemnations. So conservation easement land can still be condemned for road widening projects, utilities. Right now, that's mostly what we've been dealing with is road widening projects. But yes, a landowner with an easement, the property can still be condemned. And in those cases, the landowner is still compensated, but actually we as the land trust also are eligible for a portion of those proceeds reflective of our interest in the property as well. So we have to go, it's a process we have to go through together. And so we're unfortunately dealing with that a lot right now. Mostly small things, but it is a lot of our time. So I think that is all of mine. Here's my information. And I think we're at question time.
Great. Well, thank you all so much for your excellent presentations. We will now move right into our Q&A session. As a reminder to our participants, please enter your questions using GoTo's question box. And I believe we do have a number already. So the first question we have, I think, is really intended for everybody. It's a fairly general question and a really important one. It asks, are any of our panelists aware of any examples of land use law applied in the context of environmental justice? And do you have any ideas for how it could be used to address environmental justice issues? I think anybody's who has any insight in this, you're welcome to address it.
I mean, I would say preliminarily, there's definitely considerations for EJ issues with land use law. I think affordable housing initiatives are one example of some attempts to try to consider EJ issues and to try to diversify certain areas and to try to correct certain wrongs. I know the EPA has a really good website actually about some EJ issues and sort of the history of egregious land use actions that contributed to those issues, and then some things that are going on now. So I would definitely look at that resource.
Yeah, and I was going to talk definitely about a little bit more about affordable housing. There are land trusts. Actually, a really interesting example is the Athens, Georgia Land Trust, and they actually play both as a traditional conservation type land trust. They also have the affordable housing type community land trust. And it's a really interesting model. I know more and more places are trying to set up that what would be called a community land trust, so focus more on the housing side of land conservation. So,
Peter, did you have anything to add?
I don't think I have much to add. I mean, where we do get involved sometimes. If this is kind of more of a practical answer. If a homeowner owns waterfront property, goes out there without permits and cuts down a whole bunch of trees in an environmentally sensitive area, and our agency will work together with county, maybe with the state, and depending on where this property is located, maybe even the federal government to enforce any violations of the local county environmental laws, state laws. Sometimes we see these occur in the Chesapeake Bay critical area, and they can be very serious.
Great, thank you all. Another one, this is pretty general and I think is really, intended for all of our panelists. So whoever wants to jump in on it first, please feel free to do so. This question asks, could you talk about the juxtaposition of land use and the Endangered Species Act? Emily and Sarah, you both seem to be nodding your head.
I'll leave it to them.
You can go ahead, Emily.
I mean, I deal with it in a very different way because for us, we would see that as a conservation value. So if an area or a property has rare or endangered species, it would be a priority for us to conserve. We would write our conservation easement in a way to make sure that that part of the property, if let's say there's a rare plant, that part of the property remains undeveloped and untouched. So ours is more site specific. I know some organizations focus on certain species, depending on what's really critical in their area. So I think, we think of it from a conservation value standpoint. I'm sure there's a different perspective when you're talking about, local regulations and the Endangered Species Act. So now maybe Sarah or Peter jump in.
No, I mean, I would agree with that. I think, it comes into play in site development. And, as Peter was talking about, if you need a variance, and in Maryland, the critical area variances are a pretty popular type of variance, you're going to have to prove in order to get that variance that your project is not going to have an adverse impact on the environment. And so if there are known endangered species in your site area, that's going to be very difficult to prove that that developing that site is not going to threaten that animal's habitat. And that's, you can't threaten an endangered animal's habitat. So I think that's mostly the interplay as far as I know.
Peter, did you have anything to add?
Again, I vary. My practice really doesn't involve with the Endangered Species Act at all, but very familiar with the Critical Area Act in Maryland, and I think it complements our land that like land use and I don't think there's real juxtaposition or there's not really juxtaposed. I think that Sarah did a nice job, I think, explaining that the Critical Area Commission does a very comprehensive job of protecting sensitive areas and tributaries around the Chesapeake Bay and protecting endangered species.
Great. Peter, I think this one's directed towards you, but Emily and Sarah, you are most welcome to jump in here. Question is, are coastal waters subject to land use regulations and zoning?
You don't mean the land next to coastal waters, you mean the coastal waters themselves? Oh.
I think that's what they're asking.
My practice, I'm not really on the coastal waters, and so where we are. But yeah, you might be depending on how far off the coast you're talking about. You could be dealing with the waters of the United States or state or the waters that belong to the state. And I think where we were, where my office used to be in Annapolis, we you always get these disputes between homeowners who live next to each other and wanted to extend their piers into the waters, and there's a lot of there are certain rights that you have to extend your piers into tidal waters, and how those rights conflict with your next door neighbor's rights to do the same thing. And that's kind of that's really my experience with it.
Yeah, I think there's been some really interesting goings on in that area having to do with aquaculture, with coastal owners who aren't happy about aquaculture in front of their properties. And so they try to use land use on the land to restrict what's going on in the water, because the local land use does stop, at a point. And then we get to a point where, the state holds the navigable water for the public trust. And so there's some interplay there, but there's with restrictions on the land to stop what's going on in the water, but typically water itself would not be impacted by a land use regulation.
All right. Emily, this question is for you. Is doing an easement more difficult on historic properties because the historic nature usually comes with its own restrictions?
Well, so I don't know, obviously I can't ask the person to clarify, but I'm on it. I think a big misconception is if a property is on the National Register of Historic Places, it doesn't really come with restrictions. It's a pretty loose designation that can be broken pretty easily. So unless you've gone to the length of doing an actual preservation facade easement on a structure, the National Register doesn't offer that much protection. It can help in the case of like, a federal taking for a highway or something. It can be a barrier when you're looking at various factors for condemnation type projects. But so really those designations aren't putting a whole lot of extra restriction on the land. So for us, what's challenging on historic properties is making sure our restrictions are sufficient enough to protect those historic resources, while at the same time not putting too much of a burden on the land trust. And so, for example, if we have a National Register structure on our property, we are not in the historic preservation business, and we don't want to get into what color someone's painting their house, or if the windows they're using are historically accurate, or the molding, or all the stuff that goes into real historic preservation. So we put a lot of onus on, we would hire, basically, if a landowner wants to make an alteration to the outside of their house, they have to get our approval. We don't get into the specifics. At that time, we would probably hire our own historic preservation expert to help us decide if that was an appropriate alteration or not, but we don't try to spell out all the permitted uses when you're talking about a historic property. It just gets too burdensome on the land trust. So it is something we're very careful about when you're talking about historic preservation, for example.
Great. And Sarah and Peter, I just want to give you an opportunity if you have anything to add. If not, we'll go on to the next question. All right. I see a couple more questions. So just a reminder to our participants to keep sending them in. We really appreciate it. This question, I think, is really intended for everyone. Is climate resilience a standard conservation value considered by land trusts?
I can speak for us. So we just went through this, I mentioned our year-long process of creating a strategic conservation plan. We used over 25 different data sets in our GIS and mapping models. And one of our important data layers was climate resilience. The Nature Conservancy, Open Space Institute, they have put out a lot of really interesting data to identify properties and areas that are more resistant to climate change. So I think a lot of land trusts are considering that data more and more, and prioritizing those properties that are not going to be as negatively affected, and can be more resilient to change. I know coastal land trusts are very concerned, if they're trying to conserve land for perpetuity and their properties might all be consumed under sea level rise. So I know the coastal land trusts have their own set of conversations they're having that we in Tennessee just aren't having because we don't have any coastlines. But yeah, so I would say it's more of a data, and then we're very, here in the Southeast, we don't talk that much about climate change. So while we consider it in our, in our conservation priorities, it's doesn't tend to be our messaging, where in other places it might be more of a focus of the messaging of the conservation organization. So.
Peter or Sarah, do you have anything to add?
I know that climate change and coastal resiliency is definitely something that people are starting to incorporate into comprehensive planning. When we're thinking about creating forward-looking documents and thinking about the future, we have a lot of sensitive areas in Maryland and the Chesapeake region to these issues. And so it is important that folks think about it in the planning, and try to maybe divert future planning away from those coastal areas that are going to be subject to that.
Great. So this next question I think is a really timely question. My only note is it has the potential to be politically charged, and we are a nonpartisan organization, so I would ask if we could just stick to the policy issues and legal issues here rather than the politics. But could you please talk a little bit about the seizing of land for the building of the border wall, excuse me, and some of the underlying regulatory issues and equal compensation in current legal actions?
That is not my area of expertise.
Sarah or Peter? No?
I mean, all I can say is that, you know, like I talked about in my presentation, the government can take your property if it's for a public use. And, you know, that was the Kelo versus City of New London case. There's a lot of interesting things that have happened since that case. There's a recent movie you can watch about that. You can stream it and watch, and that created a lot of change in constitutions across the country because people were really surprised in that case about what met the definition of public use. And if, you know, if the project is for public use, then your protection, that your constitutional protection is to get paid for it. And that, I think that is very surprising to people, that their property can get taken and that they, you know, they be handed compensation, and then that's how it goes. So I don't know really anything very specific about the border law project in the context of eminent domain, but eminent domain is, you know, interesting topic and one that is worthwhile for people to educate themselves on. I know with the pipeline projects that have been going on in the eastern United States, a lot of people have been, you know, have had some unwelcome surprises about when eminent domain can happen and your rights in relation to that.
I think that's right. I think people really don't know their rights when it comes to takings. You know, we here, I think here in Maryland, they're building a light rail across the state, and and the light rail is going through minority neighborhoods, and I think people were really surprised that they could do that. And I know they're having trouble getting representation, and so I expect that there may be similar issues down at the border as well.
Great. How is land use law applied for the redevelopment of contaminated areas like brownfield or Superfund sites? Are there restrictions on what can be developed or on that type of land?
I think if you're building on a brownfield, you know, you're probably dealing more with someone more of an environmental attorney than a local land use attorney. But if they cap it and comply with the law, I think you can see they can pretty much do anything they want. And you can see that in Baltimore, where in the past maybe 20 years, kind of the areas that weren't developed were brownfields, and they ended up getting capped, and now you're seeing luxury apartment buildings go up there, kind of really and they've become really the posh part of the city. I'm not sure if that answered the question, but you can. We're right now. My wife and I, we were looking for houses, and and there was a builder who was building townhouses on a brownfield in Baltimore City, and they were actually giving you a tax write-off because for people who bought in that particular community.
All right. I think this one is aimed for Emily, but Sarah and Peter certainly welcome your input here as well. Do you know of any environmental organizations working to acquire conservation easements specifically for the purpose of providing migration corridors for endangered species? And if so, what are the legal pitfalls of such protected corridors?
I'm trying to think of an example. I mean, I know that I mentioned Nature Conservancy, I mentioned Open Space Institute. Both of them do have some interesting data on habitat cores and habitat connectors. So looking at those, more of those unfragmented areas where wildlife can move. Obviously that gets a lot more complicated when you're talking about things like birds and butterflies. But obviously there's flyways and areas that are identified as important for migratory birds. Again, I think that's probably a data layer that a lot of organizations would consider in their local conservation planning. Because I know, for example, here in Tennessee, we have the Mississippi area that has a lot of migratory birds. We also have the Cumberland Plateau area, which has a lot of songbirds migrate to that area. So again, I think that comes into play a little bit more on where those areas intersect with your area of focus, or unless you're a national or an international organization like the Nature Conservancy, or Audubon does some direct land conservation if you're talking about birds. I would bet that there's a lot of organizations that consider that as part of their analysis.
Great.
I don't know if you have anything to add, but.
Sarah, Peter, did you have anything to add to that?
No, I was going to say Audubon. I think that would be the organization that would have the most intel on that. Maybe Ducks Unlimited also.
Mm-hmm.
Great. Well, I see just one last question. It's asking about the border wall specifically, but I think we can broaden it. Are there differences between federal takings and or state and local takings? And if so, could you explain those a little bit?
Well, so you get your federal, you have takings protection. The federal government taking your property and for the state government taking your property. From the federal government, the Fifth Amendment, and then the 14th Amendment applies that to state actions as well. You do, because of the changes that were made post Kelo versus City of London, depending on your state constitution may specifically speak to takings and may specifically define what is a public use and when your property can be taken. So state constitutions are not amended very often, but that was a situation where, because of the Supreme Court's decision on that, some states felt like they wanted to pass their own individual protections. So I would look to your state constitution and see if your state is one of those states that made some changes on the state level and more narrowly defined when property can be taken.
Great. Peter or Emily, did you have something to add to that? No. All right. Well, thank you all so much to our participants for joining us today and for your thoughtful questions. We hope you will continue to think about the foundations of environmental law, especially land use law. We're so grateful for your participation in ELI's annual summer school series, and we hope you will come back next week for the Basics of Clean Air Act. I want to extend a huge thank you to our fantastic panel, Sarah, Peter, and Emily. You all have contributed so much, and thank you for lending your expertise to our summer school. Thank you all again. Take care and stay safe. Thank you all.
Thank you.
Thank you.